Good evening. Welcome to the CCPL lecture. I'm Cora Chan, Associate Professor of Law at the University of Hong Kong. Today, we're extremely honored to have two distinguished guests, Professor Moshe Cohen-Eliya and Professor Iddo Porat, to speak to us on an important and timely topic, regaining the court's legitimacy in the age of political polarization. Professor Cohen-Eliya is a full professor of constitutional law and the former president of the College of Law and Business in Israel. Prior to his service as president, he was the dean of the law school at the college. He's a council member of the International Society of Public Law and the founding editor-in-chief of the journal Law and Ethics of Human Rights. Professor Cohen-Eliya is no stranger to our faculty. This is his third visit to Hong Kong U in recent years. This time, we're honored to welcome him back as Cheng Yu Tung Visiting Professor of Law. Moshe, thank you very much for visiting us and a very warm welcome. Professor Iddo Porat is an Associate Professor of Constitutional Law at the College of Law and Business in Israel. He's published widely in constitutional law and legal theory, including recently an interesting article on ritual animal slaughter, male circumcision, and proportionality in the Oxford Journal of Legal Studies, and a volume on towering judges co-edited with Professor Rehan Abiratna, who's in the audience today. Thank you very much, Rehan, for attending. Iddo, thank you very much for joining us by Zoom. We hope that we'll be able to host you in person before too long. Thanks very much for joining us. Many of us, myself included, have benefited enormously from the work of our speakers, who are world-renowned experts in proportionality, amongst other topics. Their publications include their influential book, Proportionality and Constitutional Culture, published by Cambridge University Press in 2013. We're privileged to have them speak to us on their new project on Supreme Courts and Polarization, which is a book project for Cambridge University Press. Let's welcome Professor Cohen-Eliya and Professor Porat.
Thank you, Ryan. Thank you very much, Cora, for a very warm and kind introduction and for inviting me here for the third time. I think now I'm in HKU and I almost feel as if I'm at home here. So thank you very much for a very warm hospitality, and hello, Iddo, back there in Jerusalem. You have a nice view from your window. So a few months ago, at the ICONES International Conference in Poland, Professor Tom Ginsburg approached Iddo and told him, look, Iddo, I collaborate with many people and along many years, but there is something unique about you and Moshe. You have truly a monogamous academic collaboration. So I think this is indeed a true description. We are working together for about 15 years, and to some point, we are almost inseparable in the way that we work together, we co-write together, we think together. So Iddo is really also a very good friend of mine. So what we are attempting to do is to try to identify deep processes on a global level. So with the emergence of global constitutionalism, we made extensive research on the doctrine of proportionality, which is the lingua franca in global constitutionalism. And with the populist revolt against global constitutionalism, we also did some research to the extent to which proportionality actually fits this age of populism. And now we have decided to tackle a different topic, the topic of the dramatic rise in the level of political polarization across the globe and its effect on apex court. This presentation would not go much into the details. You can find much more details in the article, the draft article that we have sent. Rather, we would present a broad brush argument. And the core argument is the following: the global rise in political polarization across the globe actually accelerated the politicization processes that have put the Supreme Court across the globe in a certain kind of a legitimacy crisis. So we identified three legitimacy models across the globe. the Westminster model, the US model, and the Continental Europe model, and we describe the way in which political polarization has shattered the basis of legitimation, and then we move on to present two strategies in which the courts can retain or regain legitimacy in the age of acute political polarization. So let's start. Political polarization actually takes place when the political center is weakened and centrifugal power pushed to the extreme. Centrifugal is the Latin word that actually means running away from the center. And this can happen either by the growing power of fringe parties at the expense of the more traditional big centrist party, or it can happen in a different way in which more extreme element within the big party takes control and push the political parties to the extreme. So this funny cartoon by Elon Musk actually, I think, very nicely captured the way in which the Democratic Party has shifted to the left, but the same goes also to the Republican parties with a very dominant effect and influence of the evangelist political camp. So we live in an age in which in which ideology has turned out to be an identity. In 1960, when Americans were asked, how much are you willing, your son and daughter, to get married to a person belonging to the opposing political camp, only 4% said that they will disapprove such a marriage. Today, the number is no less than 50%. Political scientists use the term affective polarization in this respect, which is basically the extent to which we like the in-group, or more distressing, dislike and even hate people belonging to the opposing political camp. So this is a sense of affective polarization. Political scientists have constantly shown a rise in the level of political polarization across the globe. It doesn't happen to the same extent in all countries, but generally speaking, this is clearly a global trend. The prime example is the US, although, by the way, the US does not experience the highest level of political polarization. Spain and Hungary are more polarized than the US. But what you can see in this graph is a sense of what is called elite polarization, the extent to which both parties, the Democrats and the Republican, voted together. And what you can see is that today, America is experiencing almost the same level as political polarization that it has experienced during the Civil War. But in the 19th century, it was a war between the northern states and the southern states, while currently it is a virtual war so far between the red and the blue states, the Republican and the Democratic states. So what may account for the dramatic rise in political polarization across the globe? There are many explanations, and I will very briefly highlight only 4 of them on the more global level. So one explanation is very well known by Piketty, relates to the dramatic rise in economic gaps between the ultra-rich and the poor and the middle classes on the other side, which increases social alienation. Another explanation relates to waves of immigration that took place most notably in Europe, creating social and political stress and thus intensifying antagonism between the different fractions in society. A third explanation relates to the rise in social media, which erodes common grounds for interchange of ideas and create instead isolated echo chambers. An echo chamber is an environment where a person only encounters information or opinion that reinforces its own. We actually echoing ourselves in the social media, and that creates a confirmation bias. And finally, social alienation associated with globalization, which causes growing differences between the city dwellers and the rural dwellers, between the bureaucratic and the free trade mobile class and the local blue collar classes. And this was very colorfully described by David Guthart as the difference between the anywheres and the somewheres. The anywheres are people like me, academic, global entrepreneurs, business person, high-tech people that can take their laptop and actually work everywhere across the globe, while the somewheres are people that are firmly attached to the ground. People living, for example, in the US in what is called the flyover states, or in rural Great Britain, those people, the somewheres, actually suffered a lot from globalization. Globalization, to a sense, ruined their life. It took their job, and all of their fury, their anger, they shift toward this global elite that gained from globalization. So these are the main 4 reasons why we are experiencing highest level of political polarization these days. So I want to take it from a general description and focus more on courts, but it's also interesting to note that political polarization does not only affect courts, it affects other social and political institutions. For example, in the US, the media and the academia have always been conceived as left-leaning institutions, while the military and religion were always conceived as right-leaning institutions. But what actually happened is that their conception has been much more radicalized. They are more and more conceived as leftist or rightist. This is the kind of partisan phenomenon that happens with political polarization. So let's move to court. And of course, courts are not immune from the effect of political polarization, especially when are engaged in value kind of analysis. So in our book project and in the paper that we presented, we differentiate between 3 models: the Westminster, the US, and the European one. With the Westminster model, it's the British one. We call it a model that is based on a professional legitimacy. So first, let's define what is the Westminster model country. It refers to a set of countries that have formerly been under the British control and have inherited central features of the British parliamentary system. All Westminster countries have departed in one way or another from the traditional, the original British model, but they still retain certain common features that give them some kind of a family resemblance. The countries that we are analyzing is the UK, Canada, Australia, New Zealand, and Israel, with an emphasis on the UK and Israel because the effect of polarization there on court is much more pronounced. So one of the central features of the Westminster model is the idea of parliamentary sovereignty. This affects the level of political involvement from beyond the court. First, it caps the involvement only to administrative law because the courts are not allowed to strike down laws. And also within administrative law, a highly differential test is applied, the traditional Westbury test. Okay? So originally, the courts were not involved in politics, and this was also reflected in the nomination process, which was relatively professional one. And by the way, in 2006, the UK Supreme Court has been established, And the model of nomination of justices to the UK Supreme Court is almost entirely professional. It's a committee with only judges and professionals sitting, with the Lord Chancellor having only a veto. So that's a revolution. And this is the classic professional. So what happens in the Westminster country model? There are several reasons why this model has been destabilized. First, different kinds of modes for judicial review. If we go back to the famous work by Tashnet on strong and weak forms of judicial review, weak forms of judicial review were introduced into the Westminster, especially in the UK, New Zealand, Australia to some lesser degree, and intermediate and even strong forms of judicial review were introduced in Canada and in Israel. So courts started to get into the more politically oriented issues. And at the same time, the court adopted notions of proportionality that it took from European countries. For example, when in Canada in 1986, the Canadian Supreme Court in Ox adopted the proportionality analysis, it took it from the German conception. It didn't mention the German constitutional law, but this is where this doctrine actually originated from. So we have courts having power to strike down or at least to deal with political issues. They incorporate the notion of proportionality, which gives them greater leeway. And the doctrine of Westbury is being shifted a bit to a side, and proportionality takes place. And this is the notion of proportionality. And then came polarization. With the rise of political polarization in the UK, especially revolving around the Brexit, it has definitely affected the UK Supreme Court. You might recall the two famous Miller cases in which the Supreme Court actually forced Boris Johnson to go through Parliament in order to approve the Brexit. The court had to suffer a very strong backlash from the Conservative government, with Boris Johnson as suggesting to strip power from the court, or on the other hand, to conduct a public hearing, the same hearing that are taking place in the US. So what the UK Supreme Court has done, it has done a U-turn. It has applied a very differential standard of view in view of the reaction of the politician. But while the UK Supreme Court, which is relatively a new player in the game of global constitutionalism, can do this U-turn, the same does not follow with regard to Canada and Israel. Because in Canada and Israel, we have a very settled law with regard to judicial review on primary legislation, goes back to 40 or 30 years, okay? So it's very hard to go back into depoliticization strategies. So if we take Canada, for example, in 2014, there was a clash between Chief Justice McLachlin and the Conservative Prime Minister of Canada, Harper, regarding nomination. Eventually, Harper has managed to nominate 3 conservative judges to the Supreme Court. Now there is not a majority, but a third of the Canadian Supreme Court is composed of conservative judges. So we see how political polarization has turned out to be court polarization in a sense. And the debates are primarily around the living tree doctrine, the extent or the scope of the charter rights, the level of judicial review. So in Canada, we see signs of a creation of a conservative camp. If you go on to Israel, You know, in Israel, the highly charismatic Chief Justice Aaron Barak actually has turned the Israeli Supreme Court into a very activist court. Barak has written extensively about proportionality, has a theory about judicial review, and has a lot of charisma, and has managed to shift the court into a very activist style of judicial review. And, you know, now Israel's judiciary is experiencing a terrible backlash from the right wing, which eventually led to a creation of a conservative camp also within Israeli Supreme Court. Out of 15 justices sitting on the Israeli Supreme Court, we have about 4 to 5, again, almost a third conservative camp. And this camp is getting larger and larger from year to year because usually the liberal judges are resigning and then more conservative justices are entering the Israeli Supreme Court. And what Israel is now experiencing is the deep polarization around the decision of the Attorney General to indict Prime Minister Benjamin Netanyahu for bribery and a breach of trust. And here you see Netanyahu with all his ministering before entering the court. This trial has put Israeli politics into 5 consecutive elections within 3 years. The next election is a week from now. I'm flying back to Israel to vote in time. So this is the Israeli kind of situation. So the result of this polarizing the court and the backlash from politicians has created a polarized way of perception. What you can see here that the Israeli Supreme Court level of trust has reached its lowest peak ever. It used to enjoy 85% support. Now it's only 49, with a very polarized conception and support. With the left, 87% of the left have trust in the Israeli Supreme Court, with only 32% of the right-leaning people having trust in the Israeli Supreme Court. So we see polarization not only in nomination, not only in doctrine, but also in perception through the public trust. Okay, so that's the Westminster model. Let's move very briefly to the US, which is the paradigmatic case. In the US, the legitimacy basis of the court relates to the fact that it's a federal system and a pluralist society. Okay? And as a federal country, the US needed a constitution that is superior to legislation to regulate the relationship between the states and the states vis-a-vis the federal government. So the US Constitution is based on checks and balances in which the authority between the different branches is strictly divided in a way that creates competition between the branches and prevent one branch to gain too much power. So the judicial enforcement of rights, therefore, fits the model of an umpire, okay, between the different sources of power and a fair rule of competition within the pluralistic worldview. So during his confirmation, Chief Justice Roberts in the US, in the Judicial Committee of Senate, he explicitly referred to the notion of umpire to describe the appropriate role of judges in the US Supreme Court. Hence, as an umpire, the role of the judge in the US is to supervise division of power and making sure that the system of checks and balances operate correctly and fairly. So let's check what's the effect of political polarization and the rise in political polarization in the US on the courts. First, in terms of nomination. So I think if you go back to 1980 with the nomination of Antonin Scalia, or to the 1990s with the nomination of Ruth Bader Ginsburg, very different kind of character, one very leftist, one very right-wing, and still they gained support also from members of the Congress or the senators that belong to the opposing political camp. What we are experiencing today is a very partisan way of confirmation. In a sense, if you go back to the last nomination of Amy Coney Barrett, the numbers are quite staggering. 52 out of 53 Republicans voted in her favors, with all 47 Democrats voted against. So nomination in the US is extremely partisan. Let's go to judicial decision making. You're looking at these colors. You're not sure what they represent. They represent ideological support that has been given to each judge across more than 70 years, okay? So what you can see is that in the 50s, the 60s, you can find judges that shifted camps from the left to the right, from the right to the left. And what you can see in the last 20 years is very distinctive camps, which actually duplicates the political line of the party, okay? So it is very clear that also within the judicial decision-making, there is a kind of a reflection of political polarization and partisanship. And also in terms of trusting the court. Look at that result, which was, it's a poll that was published just after the publication of the draft of the Dobbs decision, the abortion case in America. You can see that the level of trust in the US has reached its lowest point ever, 25% trust the court, with, again, polarizing effect. 39 of Republican percent support the court, with only 13% of Democrats have trust in the US Supreme Court. This is a major legitimacy crisis for the US Supreme Court. It's the opposite way from Israel. In Israel, the court is perceived as left-leaning institution, and in the US, it is perceived as a right-leaning institution. Okay. So that's the umpire. There's no umpire. Everything is so partisan in the US now. Let's move to the last model, which is Continental Europe. The legitimacy of the European courts can be described as organic. What is an organic conception of the state? It's an idea in which all institutions, individual, civil society, all organs of the nation collaborate together to realize shared value. This is a notion, very romantic, very Hegelian, very German, that still persists even after the Second World War in Germany. So according to the organic conception of the state, the role of constitutional courts and their basis of legitimacy is the idea of applying, realizing, promoting, identifying the shared value of the general society. So the role of constitutional court is political in a sense. Okay, this represents a kind of collaboration. And if you go back to the book of friends of ours, Alex Sweet, and I remember I was asking, why did you call the book Governing with Judges? And the word with is very important. It actually, I think, reflects the notion that judges are part of the political enterprise of realizing shared value. And by the way, they are explicitly authorized to strike down law in the Constitution. So there is less a problem of the anti-majoritarian problem that we used to encounter in the US courts. Okay. So what we also see in Europe is that the nomination process to the Constitutional Court is built on the requirement of supermajority. That means 2/3 of the parliament member need to approve. And what this creates is a kind of moderating effect, consensus, and consensus among the big major political parties that are centric, that are more liberal oriented. And this model worked very well until the populist revolt, okay? So what we see in Europe now, it's still the beginning of the phenomenon, okay? But still we see cracks in the consensus-based model. Just to give you two examples, one is the rise of the populist right-wing party, the People's Party in Switzerland, okay? Which demanded its share in the nomination process, because if they actually won the election, and suddenly you have a populist political party which has an effect on who sits at the Constitutional Court. And if we look at Germany with a very ultra right-wing party, the Alternative für Deutschland party, this political party gained sufficient power in one of the Länder in order to insert its own judge into one of the Länder constitutional courts. So far, we don't see any effect of these changes, on these pressures, on the judicial decision-making in Europe. But as long as the populist revolt succeed, and more representative of them would sit in the parliament, they would require their share in the nomination process, and that would certainly put some more pressure on the consensus-based model that characterized the European. So I will stop here, and Iddo, you want to speak without the PowerPoint for the beginning?
Yes, please do the stop share, and I'll tell you when to share the screen again with the next slide.
Okay. Yeah, sure.
All right. So, hello everyone, and I'd like to start by joining Moshe in thanking all of you for coming. I'm sorry I can't see all of you, but I feel your presence, and thanking the organizers in Cora in particular for arranging this, and saying that I'm very happy and honored to be at this event. And I'm sorry that I cannot be here physically in this beautiful room you have. I will pick up from where Moshe stopped, and I'll try to be a bit brief so that we'll have enough time for a discussion. And my part of the paper, the part that I'm going to present, follows Moshe by asking the following question, which is, what is to be done? So what is to be done, following what Moshe has presented of the first part of the paper, which presented the challenges for legitimacy to courts that polarization has put in three constitutional models, what we can do and what kind of strategies we can adopt in order to regain legitimacy of courts. So if the legitimacy crisis in all three systems to some extent has to do with politicization of courts, or in particular, the idea that courts are not objective politically, or there's some kind of threat to their political legitimacy, then the first strategy that comes to mind is, we call that depoliticization of courts. So taking politics out of the courts completely, or taking the courts out of politics so that it can regain its legitimacy and not being entangled with politics, right? So either taking courts, judges away from junctures where they can be involved in politics, or taking politicians away of junctures where they can be involved with judges. The other strategy that we identify, so we identify two strategies. The other, which we call balancing, starts from the opposite premise or starting point, and that is that politicization of courts or some kind of political involvement or nature of courts is here to stay. Either it is inevitable and hard to fight, or it is maybe advisable or part of the system. In any case, it is here to stay, and the problem lies, or the way to regain legitimacy is by regulating properly the political nature of the court, and in particular, installing balance in terms of political makeup of courts or political involvement in courts, so that no one political side gets control or gets unfair representation on the court. So first one is depoliticization, second one is balancing. And what I'll do now until the rest of my part of the talk is to explain or show how these two strategies can manifest in the three models that Moshe presented, what it means to adopt any of the two strategies in each of these models, what it might mean, and how can we regain legitimacy by adopting each of them. And then at the end, as far as I have time, to discuss three general observations regarding what these two strategies mean and the interrelations between them. Okay, so now I think it's a good time to put the share screen back, Moshe.
Yeah, it's
so
back.
Thank you. These are the two strategies, depoliticization and balancing. And we start with the Westminster model. Actually, if you can move to the next slide, this next slide shows depoliticization, and soon we'll see why Boris Johnson or the idea of taking the Constitution from the courts represent depoliticization. Next slide, please. This is metaphorically balanced, and then next slide, please. Okay, so we'll stay here for a while. This takes us to the Westminster model and to the first strategy of depoliticization, okay? So if we think about the Westminster model and the kind of challenge that polarization put in front of for its legitimacy basis, then recall that the legitimacy basis used to be a professional court, and polarization added up to other factors to make a threat to that professional model of the court. So a way of regaining legitimacy for the court and regaining the professional legitimacy would be depoliticization. So the first strategy, depoliticization, seems the most natural one. And the idea is basically to turn the clock backwards or get the professional model again and get the court away from the political aspect that it has acquired over the year or been entangled in over the years. So we can think of three main ways of depoliticizing the courts in terms of its decision-making and powers. The first would be take away or reduce its capability of judicial review, which is what we have here on the slide, and I'll refer to it in a minute, which refers to the UK Supreme Court. The second might be changing doctrines of the court to make them more differential and more formalist, thus less political or less allowing for political consideration to enter. And the third one might be making harder or heightening procedural barriers for judicial review. Okay, these three relate to how we can depoliticize courts in Westminster systems in terms of the judicial powers and judicial decision-making. So the first would be to reduce or even take away the little power of judicial review that has been acquired in the UK, for example, or the more considerable power that it has acquired in Israel. And here we see several reform suggestions that were attributed to Boris Johnson's government a few years back. They were quite very much in the agenda, not so much now, of course, but even not so much in the last year. But beforehand and after the the Brexit decision, they were very much discussed. And they included, as we see here, reducing the constitutional powers or overhauling the constitutional power of the court, maybe even changing the name from the Supreme Court, so it won't suggest that it has constitutional powers as the American Supreme Court, maybe even taking particular chunks of judicial review away from the court, such as the ability to review decision of cabinet ministers or to review decision regarding elections or asking or calling for elections. So, and in Israel, we can see reform suggestion to the same extent or following a similar idea. In both cases, they usually come from the right side of the political spectrum. As to if we think about doctrines, the idea might be to, and this can come from the court or from outside the court, to do away with doctrines such as proportionality or reasonableness in the more open-ended way, not in the Wensbury way, and adopt more differential modes of review instead. And we can think of procedural barriers such as standing or justiciability being raised. Again, in Israel, they've been strongly reduced or even obliterated, so we can think of raising them again, all in the sense of getting the court as far as away possible from politics. Now, the other area where we can think of where we can depoliticize the court is in terms of nominations. And here, please, next slide, Moshe. Okay, so in terms, no, not next slide yet, sorry, back one slide again. We'll get to that soon. In terms of nomination, that would mean getting politics out of nomination, right? The way to depoliticize, if we want a professional model of the court, we want politicians as much as possible out. Now, although the depoliticization avenue or strategy might be the most natural one, we can see in terms of Westminster, we can see actually the balancing strategy being suggested as well in terms of Westminster countries. And balancing, this is where we get the next slide, would mean actually the opposite in terms of nomination. It would mean increased political involvement in nomination, or at least more explicit political involvement in nomination. So making the political aspect explicit rather than hidden or unregulated. One aspect might be having hearings for prospective Supreme Court justices. As we can see here, this has actually happened already to some extent in Israel, and there were talks about this also by the Boris Johnson administration regarding Supreme Court nominations. So making it explicit and then regulating it so that there will be some kind of balance in terms of the nomination. For example, in Israel, a decade or a decade and a half ago, there was a new law or a change in the law that required supermajority in nomination in the nominations committee, and that for nominating Supreme Court justices, and that basically requires some kind of balance between the two opposing sides that were vying for power within that committee. So this is one way of regulating political power or balancing political power, and obviously there are other possible ways. Good. So next slide would be a kind of summary. If we talk about Westminster model and depoliticization, the first strategy in terms of nomination, this might mean no politician involved in nomination in terms of decision-making, taking away or limiting judicial review over governmental decision, enhancing procedural barrier, or different doctrinal doctrines of review. It should be differential, actually, doctrine of review. In terms of balancing, and note that the balancing strategy would require changing the basis of legitimacy. So changing it from what used to be a professional basis of legitimacy to some kind of a basis of legitimacy that allows for political involvement of courts and political nomination, something maybe along the lines of the American or the European basis of legitimacy. So in terms of nomination, balancing would mean increasing political representation in nomination, maybe, and regulating, maybe supermajority hearings for nominees, also term limits, which we discuss in the paper. And in terms of decision-making, which I didn't discuss as of yet, I'll just mention it here. A supermajority, for example, for abolishing laws or setting aside laws which was suggested in Israel, for example, or was suggested for some decision in the UK, is one way of creating balance in terms of decision-making of the court. En banc is another way of maintaining maybe balance if we get the cohort of justices balanced. So next slide, please. We get to the US. And in the US, balancing is the more natural way to go rather than depoliticization, since the system is already so much built in politics in the Supreme Court and it is already so much politicized. So balancing is the natural way to go. And indeed, there's much ingenuity and imagination in law reviews lately of how we can balance the court. This law review, Yale Law Journal article that we see is one example by Epps and Sitaraman. They call it How to Save the Supreme Court, and they envision two rather radical changes in terms of nomination that will allow of balancing the political power of the court and taking away the kind of one-sided political dominance that it has now. One they call a balanced bench, which they envision as having 5 justices elected by Democrats, 5 justices by Republicans, and these 10 then nominate together another set of 5 justices that will reside for 1 year at a time. Okay, so this is kind of a way that they try at least to think of for balancing. Another even more radical way is having a lottery among all federal circuit federal justices each year of 9 justices. Again, a way of take away political advantage in the court and balancing in a way. And we can think of ways in terms of decision-making as well. We discussed them in the article of balancing political power. But interestingly enough, although depoliticization seems very strange maybe in the atmosphere of the Supreme Court of America, it is very much on the agenda, especially of progressive circles and writers. And this is, again, one example in a law review article called Democratizing the Supreme Court by Dorfler and Moyne. And what they suggest is basically to depoliticize the court and take away or reduce its power of judicial review as much as possible within the constitutional scheme or as much as feasible. And they view it as a better strategy than balancing the court, right? Or maybe a more feasible one in terms of how they are, what they think is feasible. So we have quite a lot of recent talk about taking away powers from the court or making other adjustment that will reduce its political involvement and bring democracy back to Congress or maybe to the people. Something that we used to hear almost strictly from the right wing or a more conservative side of the map now is very much on the other side of the map discussed. So this is a summary in terms of the nomination. This is, we don't have so much that in terms of depoliticization, more in decision-making, strict on authority. And in terms of balancing, we have a balanced bench lottery, and we discuss in the paper also the idea of panels and supermajority. Finally, we get to Europe. You can put this slide on. In the continental model, the threat to legitimacy is not as acute. We call it, as you may recall, cracks in the consensus-based nomination model. So the idea of depoliticization is not so much on the agenda as the court is, as the system which includes political representation in the nomination seems to work pretty well, and the court is not so much accused of being non-objective politically. What we might discuss is how to fare with these new kind of parties from fringe parties like the AfD, whether in particular to include them now within the nomination process or whether to exclude them. And that has to do mainly with balancing and nomination. We discuss other issues as well. And again, I refer to the paper for some more details. Finally, a couple of general observations, okay, and questions. Again, I'll be brief and we can discuss this more in Q&A. Can we have both strategies, right? Both depoliticize and balance, right? There is an obvious tension there because if we want to depoliticize, right, then we mean a professional court, and why engage in balancing politics? There's not supposed to be any politics in nomination anyway, because the court is professional. But we might think of a lexical order here. Let's say we are conservatives in Israel. We say, well, there is currently a dominance for liberals. So the first step would be to balance the court. And then next, this will allow easier depoliticization. But we want to have both right now. Our long-term objective might be depoliticization, but we need balance now. Next slide, please. Okay, now this has to do with what exactly we mean by balancing, okay? And when we say we want to balance political power, what we might end up with is a kind of consensus. So if we have 5 justices and 5 justices and another 5 which are kind of in the middle, then they might it might bring moderation, or it might allow for extremism in the way of dividing the spoils. I get my cases, you get your cases, and we strategically divide the spoils between us. And these are 2 very different ways that balancing might actually affect the court. Now, we discuss also the distinction between balance and representation. Do we really want to have half-half as absent Sirataman discussed, or what might be more applicable in Europe, a proper representation, and how would that look like? So these are 2 different manifestations of balance. I'll skip this slide and get to the last one, please. And finally, what we mean by depoliticization. Do we actually mean, or what it means is simply weakening the court, right? And that's not really depoliticization. Maybe it's a political move. The political move is to introduce a weakening of the court as a check in the political system. 2 remarks in that regard. 1, we do not discuss here semi-authoritarian or countries where we do not have proper judicial independence, so that we assume a reasonable level of judicial independence. So the court remains independent, even if not political. And second, we should note that we have now people who are very much, let's say, concerned with human rights that ask for a depoliticization of the court. So they do not view, so if we think of progressive in the US right now, they view a situation where you can have both kind of human rights protections and a depoliticized court. So at least this must be discussed as an option. So I'll stop here and looking forward to Q&A. Thank you.
Thank you so much to both of our speakers for this captivating and very clear and illuminating presentation. We've also had the opportunity to read a very dense and thoughtful and insightful paper. The project is absolutely fascinating. I can foresee this to be a trailblazer. So after your book is published, a lot of people are going to respond and start writing on judicial legitimacy and polarization as a result of the book. And I'm sure that many of us have comments and questions, but while some of us are thinking perhaps I could kickstart with some thoughts. In all three models, courts are expected to be a non-partisan arbiter of legal disputes. And by non-partisan, I mean non-partisan in the sense of not biased in favor of either litigating party. So, and this is the case, this is the role expected of the courts, not just in the US model, it's the role expected in the European and the Westminster model as well. And to perform this role across all three models, the courts are expected to draw on values that are not their own subjective values. There might be various conceptions of what these values are. They might be shared community values, as you put it in the European model, or the UK courts might refer to fundamental values of the Constitution, however they're defined. And the appeal to these values is expected in the case of all three models, and not just in the European model or in the US model, because by nature, the answers to constitutional questions may not be clear from the legal sources, and the courts need to make value judgments. So for example, even in the Westminster model, what the Parliament's will is may not be clear from the legal sources, and the courts will have to ascertain what parliamentary will is in light of constitutional values. And what I find really illuminating from your paper is that you've shown us how political polarization affects both the normative legitimacy of the courts by making it more difficult for the courts to fulfill this role of a non-partisan arbiter to legal disputes, as well as the sociological legitimacy of the courts by reducing public perceptions that the courts are impartial. So how is normative legitimacy affected? You've explained that polarization makes it harder for the courts to distill shared constitutional values to determine legal issues. It doesn't mean that the distilling of constitutional values is impossible in a polarized society. It's just that it's going to be more difficult. And finding the correct answer to a legal question would be more difficult in a divisive society. As you've explained, in an age of polarization, politicians may appoint judges who are strongly partisan. And in those circumstances, it'll be difficult for the court to perform the role of a neutral arbiter. But you've also explained that polarization affects sociological legitimacy. When judicial appointments are ideologically partisan, and when judges vote almost always along partisan lines, public trust in their partiality is weakened. I have two very quick comments on this. The first comment is that I understand that the project is not primarily normative. Your argument is that assuming that we want to rebuild the court's legitimacy in the age of polarization, then here are the possible devices to do it, a toolkit, as you put it in the paper. And I think that's a perfectly justified focus, especially given the early stage of research on this topic. But I think that even if that is the focus, it would be helpful to set out more thoroughly the potential risks of adopting the proposed strategies, as well as the considerations that have to be weighed to decide whether to adopt them, and to say explicitly that the strategy should be adopted only when all those considerations balance out in favor of adopting them. So this is not a normative position, but to set out the different considerations for people to consider the normative question. And I think it's important to do that even if the project is not normative, because for a strategy to be considered viable, that is for a strategy to be laid on the table at all, we need to envisage situations in which the strategy can be justified. So we need to know that they could indeed enhance legitimacy and not be counterproductive. And this is particularly important given that the strategies are not uncontroversial. So the first set, as Iddo has pointed out, might be seen as weakening the court, and the second set balancing eventually to try to make the court look more like a political organ. So I think even if you're not trying to advocate for particular strategies, it's important to set out all the different considerations and the relative merits and risks of the proposals. For example, the goal of rebuilding judicial legitimacy may not be the only game in town. I agree entirely that it is an important goal. But even for liberal democracies, it may not be an overriding goal. So that goal might be overridden by the goal of keeping a strong court to check the executive in some circumstances. But even if rebuilding judicial legitimacy is an overriding goal, the court earns its legitimacy not just from impartiality, but also from its ability to arrive at correct answers to legal questions. And one risk of strategies like balancing would be that in some circumstances, the court may, as a result of a compromise between ideologically opposed judges, arrive at decisions that are suboptimal from the point of view of justice. And if judges accept a suboptimal solution, or if we allow representation of extremist camps on the bench, the extremists, they're popular, but they deviate from the country's long-standing values, then the courts may indeed appear to be less partisan, but that would come at the cost of principled adjudication. And I also think that it's important to consider the long-term effects of some of the strategies. For example, will they entrench polarization in society? Will they be very difficult to reverse? So how are we going to transition out of those strategies once society becomes less polarized, etc.? So in short, the first comment is really to set out all the different risks of the proposals and the different considerations for guiding when we should adopt the strategies. My second comment is a very quick one. I wonder, in addition to the two strategies, and I agree that the two strategies, they're on the right track, they're very intuitive. I wonder whether a third strategy could be added, and that is to enhance the requirement of reasoned justification from courts in divisive issues. And this builds on your very insightful work on culture of justification. It's basically to require the courts to take their duty to provide public justification, particularly seriously on issues that are controversial. And in a way, that is what courts in all three models should do, regardless of how they're appointed, regardless of the composition of the bench. Judges should evaluate the merits of opposing arguments and to give reasons that even the losing party can accept. So could this be the ultimate way to show that the courts are non-partisan even in times of polarization? Or do you think that this won't work because in an age of political polarization, people are just not going to listen, they won't be willing to reason? So just some initial thoughts and initial reactions. Thank you very much for a really, really exciting project.
Moshe, would you like me to begin quickly? Yeah. So can you hear me?
Yes, very well.
Great. So thank you so much, Cora. This is absolutely wonderful and fascinating and really important points, which we will definitely take on board. I want to address your 2 points. And the first one, I think, is definitely correct, both as a project for the upcoming book, and even maybe in a way we can address in this particular article, and that is, what are the costs of adopting each of these strategies? And I just want to emphasize in this regard that when regarding this cost, we should, of course, consider the cost of staying in the current position, right? So what might be the cost for the US, for example, to be stuck in the current position where the court enjoys such low levels of trust and is simply regarded right now as a conservative organ, or in Israel, where it also has seen considerable reduction in its trust and is also really not trusted at all by great chunks of the population on the right side of the political map. So we have costs on that, which we should, of course, balance with the costs that you, I think, rightfully mentioned. Another point is that if you say that what we might want the court to do is not necessarily have legitimacy, but be strong in order to be a check, I think an argument might be that it needs legitimacy in order to be strong so that it can perform, because it basically is an institution that lies pretty much strongly on its legitimacy as a fair arbiter. So in order to be strong, it might need that. And finally, the idea of a culture of justification, I think, is great. And I think we should definitely address that. And I am maybe a bit skeptic, as you may have already alluded to, that we can go for reason justification where people are so divided, so that the basis for reason justification or public justification put in question. People live in different realities of different factual worlds. So it is harder, so that maybe these are the only two options: either get the court absolutely out or just admit that it is part of the game, rather than trying to be in the middle in a way that it is reasoned on a principled way. But I totally agree that this should be discussed as this third option. Thank you.
You hear me? Yeah. So thank you very much, Cora, for a very, very thoughtful comment. Just very briefly on each of your points. Sure, it's a work in progress. And actually, we have decided to write the book, and then we said, well, let's write an article so we can present it and have comments, the kind of comments that we received also from you and from other places. So definitely in the project, we are going to assess the different strategies from a normative perspective, even though we don't necessarily take a normative stand, but just to put on the table the costs and benefits of each strategy. One point relating to the problematic nature of the balancing strategy, it's, in a sense, you come to a point in which you ask, why do we need the courts? If we duplicate the political process and we create some kind of coalition opposition within the courts, what's the role of the court? Okay, so the best strategy, this is why we contemplated the lexical order between the different strategies. The professional model seems the best, but in some countries, take the US for example, the horses have long left the stable, and it is impossible to go back. And one last point about the deliberative democracy, culture of justification. You know, under Rawls' theory, every person that presents an argument in the public sphere has to rely on public reason. But what about religious people? A person that say, well, God appeared in my dream and told me to do this and that. They should be excluded because I don't have any evidence to their line of argument. So the notion of deliberative democracy seems neutral, but it does have some kind of disparate effect on religious people and non-liberal people. Okay, but thank you very much for very helpful comments.
All points taken. Thank you very much. And Julius?
Hey, thanks, Moshe and Iddo, for the fascinating presentation. I mean, I agree with Cora. It's such a timely and interesting project, really important. So I have three sets of questions / comments, and some, again, echo with what Cora has just asked. My first point might sound like a more pedantic point, but it relates to your account of legitimacy. It's a core concept in your project. And so sometimes you use the word political legitimacy, judicial legitimacy, legitimacy basis, and you also briefly mentioned in your presentation the anti-authoritarian difficulty. So it seemed at times you're referring to this normative legitimacy. But as I read the paper, by legitimacy, you seem to be referring more to, again, the sociological sense, sociological legitimacy, social legitimacy. And this is sort of reflected in the way you describe these three models. It's basically how courts maintain their legitimacy, how they approach, how they seek to gain, maintain how public perceives of them. That's sort of how I understood it. And so if my understanding is correct, I thought you should perhaps make that clearer, so as, I think, because legitimacy is one of those concepts that can mean many things to different people. I thought a sharper account of that would really help. My second comment relates to the connection you draw between polarization and the legitimacy of courts. So I think most of us would agree that polarization is affecting all sorts of institutions, political institutions, judicial institutions. But I thought the paper or the project itself can more explicitly point out the connections, explaining to readers like how exactly is political polarization affecting the legitimacy of courts here. So for example, as you rightly point out in the paper, in the UK, for example, the professional model has started to erode decades ago because of global constitutionalism, or one might argue even the American model. It's simply because the problems American courts are facing are simply the side effects related to playing umpire role. So if you've been a referee long enough, you're bound to piss off some people and they'll call you biased from either side already. So I thought readers will benefit if sort of more clearly identify the independent contributions made by political polarization here. So, for example, again, you mentioned early on in the paper about how polarization led to a decrease in trust in the courts, but it's unclear to me, at least, what that causal mechanism is. So what is polarization as a general phenomenon? How is political polarization as a general phenomenon leading to a distrust in courts? So I think that connection, if drawn clearer, would really benefit readers. My final sort of set of questions relates to the reform proposal. Again, it echoes with Cora's question about the balancing model. So I genuinely found them very interesting and innovative. So I think a lot of courts will find them helpful one way or another. But I thought the paper could be more upfront about the far-reaching implications, especially of the balancing model. For instance, the balancing model essentially institutionalized the political nature of the court, as Iddo says just now, it's basically changing the legitimacy basis of the court. And that's quite drastic. That's not uncontroversial. And it's completely on a different level to some of the proposals you mentioned, such as installing more standing procedures under the depoliticization model. So yes, the balancing model under some circumstances might mitigate some of the legitimacy challenges faced. But I suppose some might ask, as you were just discussing, what's the point of having a court then? How does a court really distinguish itself from the political institutions? Or are we simply proposing another arena for political contestation? So, I mean, these questions, I'm not saying I disagree with the model, but I do think that under some circumstances, there's this attraction to it. But I thought some of the deeper normative questions needs to at least be flagged, given sort of how drastic it can be in some conditions. And relatedly, it seems like polarization is a temporary phenomenon. So as you plot the US graph, it comes and goes. So if that's the case, then you might not need such drastic solutions sometimes. If the court might just wait and see, keep it professional for a while, hoping that polarization might be gone, and then the problems plaguing the court might accordingly be gone as well. So I thought one final point, which is, since polarization has happened before, it's not necessarily a new thing. It's an acute phenomenon at this point, but since it happened before, I thought looking at cases in the past might inform solutions that might help us now. So these are my sort of thoughts, but thank you for the fascinating presentation. Thank you very much.
Thank you very much, Julian. This is absolutely fantastic comment. Also, Cora, actually, I agree in almost every point that you mentioned. With regard to legitimacy, yeah, a distinction between normatives and sociological legitimacy should be added. With regard to causal linkage between polarization and the courts, that's a much more complicated project. And currently we're thinking also of engaging in an empirical kind of study, trying to measure and to compare the level of political polarization and how it affects courts. But this requires a lot of empirical work that is currently unavailable. So we don't have anything to rely on in this respect. In terms of the proposal reform, yeah, indeed, the balancing strategy can be taken to an extreme, and then the question that pops in mind is, why do we need the court? But take into consideration, for example, that the Conseil Constitutionnel in France, it is composed not only from lawyers, there are politicians sitting there. At some point, you need someone who make a decision in constitutional issues. So some kind of organ has to be the one that decides in these cases, and it can be a political organ. It doesn't have to be a purely professional one. And your point about the temporary nature of polarization is a very interesting one. We didn't think about it, but you're absolutely right. What in the US, as we can see, there were a period of time that the polarization was extremely high. But I think one of the reasons that I think that polarization is here to stay for a long time is especially the effect of social media and the echo chamber effect. Unless it is regulated, and so far it hasn't been regulated, and there is a huge debate among social scientists to the question of what is the effect of the echo chamber and to what extent it harms democracy, but a consensus on its effect would only be reached in the 2030s, in 10 years from now. So, but this is a good point to look at countries that had to deal with political polarization and what was its effect on Supreme Court. Thank you very much. Iddo, you want to add something?
First, I'd like to add my thanks for these wonderful points and very helpful. I'll just add maybe a point or two as to the causal effect. And I reiterate what Moshe said, that's quite a challenge to say anything kind of determinate. But I think what comes to my mind, and we say that a little bit, maybe should say this more explicitly, is that polarization brings things to the extreme. So you cannot so easily brush under the rug and say, well, I'll just be in this in-between position between being maybe political, maybe liberal political, maybe kind of, and being professional. It is harder to maintain this kind of vague position once polarization kicks in. So this is one possible effect of polarization. The second one is it really makes compromise or kind of dialogical solution harder as this third option that Cora mentioned. So if they're on the table before, it's harder for them to be maintained once polarization kicks in. But I definitely agree that this is something we might want to clarify a bit more once we get along. I'll stop here and allow for more questions. Thank you.
Thank you very much. I have Rehan and Scott and Albert. Albert, you have a question as well. So maybe in the interest of time, I'm going to take all three questions before passing it to the speaker. So Rehan first and then Scott. Rehan.
Okay, thank you, Cora, and thanks very much for the talk. Hi, Iddo. Nice to see you. Long time no see. I have two quick questions on this. The first is about factoring in judicial pushback against these reforms, right? So this, especially in terms of reforms that seek to limit the judicial power, I can see a court saying this is unconstitutional, right? And then you kind of go back and forth. And this isn't hypothetical, right? This is literally what's happening with the use of the basic structure doctrine in South Asia, in places like Malaysia. politicians come for the courts, sometimes for good reasons, sometimes for not good reasons, and the court says, no, you can't do that. They say, oh, we're going to amend the Constitution. Oh, guess what? You can't do that too. Right? And so there's a potential kind of snowballing effect, which for your purposes, I think would be pretty bad for judicial legitimacy, right? In the way that you mean it, the sociological kind of legitimacy where the court would really be seen to be a partisan actor in that context, right? It's basically sticking up for itself. Well, not a partisan actor, but a political actor, sticking up for itself, and sort of just wanting political hands off, even if not for good reason. So to what degree do we have to factor that in? The possibility of judges just saying no, right? Especially if it's a court that's very sort of unmoored, shall we say, from restraint, like the US Supreme Court. The second question is about the degree of polarization in a society. And so I want to ask you if there is such a thing as a depoliticizing reform in a very polarized society, because surely the reform will just be seen through partisan lenses. So half the people will basically like it, half the people will basically hate it. And again, I'm not sure how that benefits the judiciary, right? They might just be seen as, so for instance, you could imagine if some of these Samuel Moyn, Dorfler type things happen in the US, that'll just be seen as a liberal victory of some kind, right? And conservatives would not see that as legitimate. And it would, in some ways, I think, make the court seem even more political in some sense, right? So curious to know what you think. Should we care more about the degree of polarization rather than say anything specific about the US Supreme Court versus the UK Supreme Court?
And Scott.
Thank you very much. It depends where you start, doesn't it? Temporally. Acute political polarization, if you look at Europe or America in 1936 or 1956, you've got serious political polarization, right? And my concern that there's no real historical dimension to your project is that you might be stuck in the echo chamber. And the problem here is, to paraphrase, hard cases make bad legal analysis. And I think the kinds of things that you're drawing attention to may be the echo chamber of the media that you're describing. And so in that sense, I would want to see where you take into account the media in your own project in terms of amplifying or de-amplifying both politicization, depoliticization, and the judiciary.
Albert?
Okay, thank you to Moshe and Iddo for a very interesting paper. I want just to comment on this, one of the two strategies which you discussed, that of depoliticization. I think you gave the example of some proposals put forth by the UK government under Boris Johnson. So as I understand them, the proposals are mainly to do with maybe curtailing the jurisdiction of the courts or changing the existing law on what the courts can do and procedure. So so if that is depoliticization, it means some changes being introduced regarding the role of the court and their jurisdiction and powers and procedure, which in turn, such changes which would in turn have to be based on a new theory about the role of the court in society. So maybe the government in the UK at that time was not satisfied with the role being played by the English courts, UK courts at that time, and it wants to change its role by, for example, reducing its jurisdiction. So I think that the depoliticization strategy actually presupposes a change in our views to the role of the court in society, and such a change ideally should also be based on some kind of consensus in society regarding what should be the role of the courts. I think Rehan just mentioned that the reform itself may be very politicized. So I think any reform should be based ideally on some kind, on at least a minimum degree of consensus in society as to the role of the Supreme Court in the society concerned. So if people agree on certain basics regarding the role of the court, then they can work out, for example, what should be the jurisdiction of the court, or how it should be composed or nominated, and so on. So to conclude, it seems that balancing and depoliticization are of very different nature. The balancing maybe doesn't, well, as I understand it, doesn't require any change to the existing law or the existing view of the court's role in society. So I think we should further investigate into the difference in the nature of these two strategies.
Thank you, Moshe and Iddo.
Iddo, you want to start or I'll start?
Great, thank you. So again, I'll start by thanking all of you for these wonderful comments. Very helpful, all of them, very insightful. Rihan, and hi, and I hope we get to meet in person soon. About pushback, wonderful. And I think we just should add this, and I'll just say an anecdote. One of my students, when I described the kind of clash between the court and the political system, says to me kind of enigmatically, it will be resolved by the security person deciding. Asking, what do you mean? I mean, the security person at the entrance of the court, will he allow the judges to enter or not once they get into this clash where they say, no, you cannot change the constitution. The political says, yes, we can change, okay? So this is kind of the situation where we don't want to get to, and maybe some of the suggestion might not allow us to get there, but you're absolutely correct. And in the Israeli scheme of things, absolutely, it's on the table. The court would for sure say it's unconstitutional if something like that would happen. And about depoliticization, I think that there is something a bit neutral about depoliticization in the sense that it really depends, the effect would depend on what kind of government you have. So they will change. If you have a liberal government, you get more liberal. If you have a conservative government, more conservatives. Once the court outside of the picture, it's not one-sided. Right now, it's one-sided, right? Right now, it would mean a victory for one side, but it's not for long as long as we have democracy. This I think is one point that should be given. I take Scott's point to be another point emphasizing how durable polarization is, how unique it is right now, not to jump to conclusions too fast. And if that is the case, then I agree, and this should be put on the table. And then to Albert, I think, well, at least for Johnson and maybe for the conservative in Israel, the ideas of depoliticization are not a new theory, but getting back to the old theory, right? For them, it's just returning back to the way things was before, I don't know, Blair has changed and created the Supreme Court, or before in Israel, the Supreme Court itself created these changes, and back to the good old day that the court would do its professional job. So for them, at least, it won't require a new theory, I think. So that will be my answer. Thanks.
If I can add very brief comments. It's very interesting, Rihan, the role of the Indian Supreme Court. It's a very polarized society, but still the court does maintain a high level of public confidence, okay? So we intend also in the book to look into the case of India and also Brazil, where you can find courts enjoying high level of support despite the polarizing effect in society. And it's very interesting to see how did the court manage to put himself in such a position. So with regard to the question of constitutional amendment, you know, if you are the Indian Supreme Court and you have the public behind you, then you have leverage, okay? But if you don't have the public behind you, then you're in a big problem. So using the doctrine of constitutional amendment will create a major constitutional crisis. And with regard to, so this also goes to your point, Albert, about the consensus. And with regard to degree of polarization, I do believe it affects the strategy, because if you are in a very high level of political polarization, depoliticization won't work. Okay.
Thank you very much. We could continue this discussion for days, but in light of the time, we would have to close. Please join me in thanking the speakers, Professor Moshe Cohen-Eliya, Professor Iddo Porat. You two have shown us that there's nothing better than an in-person intellectual discussion. So you're the best speakers to re-inaugurate physical events in Hong Kong. Thank you all for coming. Thank you for participation. I look forward to seeing you in future events.
And thank you very much for very helpful comments. Thank you.
Well, all the best to the project. We all look forward to seeing papers and the book eventually out. Thank you.
I'll come with you.
Thank you very much.